Secretary of the Branch C. Anirban, Learned Speaker Sri M.S.N.Sarma Garu, Advocate, MC members, past chairman, senior members of the profession, and my dear professional colleagues, a very good evening to all of you. And I welcome you all for today's virtual seminar on modes of options available to banks in respect of NPA accounts regarding the DRT, ARC, NCLT, IBC and SARFAESI and various acts and various options are available, because you all know that this, because Narasimhan Committee was introduced in the 1992. So when before coming to Narasimhan Committee for this and Adhyayana Committee, both are coming into force. Before that, only overdue concept is there. After that, this NPA concept from 1993 onwards, this NPA concept has come to force. And when NPA concept has come into force, see, even banks and all people have forgotten the recovery of the installments on due dates. Because now everybody is concentrating on the recovery of NPA accounts only, not on the original due dates. Even if you go to the borrowers, one installment is due, means immediately is telling, sir, 3 installments are not at over. Okay, that will pay on third after completion of the 2 installments. We will pay the 3rd installments. They are also accustomed to the customers also and borrowers also accustomed to pay only when it has become before becoming NPA account. That is only after 2 months, the 3rd month only. If they do not pay the 3rd month installment, automatically the account will become NPA account. So in the process, when banks previously used to file in the court of law and the courts are taking a lot of time for recovering the advances because they are giving so many adjournments, and this recovery has become very difficult for the banks and other public financial institutions. So consequently, this a new process, a new act has come, that DRT. So when DRT has come into force, because RDDBFI Act, it was introduced in 1993 to provide the establishment of the tribunals, and that is debt recovery tribunals. The DRT is come into force. When the DRT come into force, first they thought that it will take EGS within 6 months it will be settled. But unfortunately, due to the various acts available in India, even the DRT also it is taking a lot of time, and consequently this they brought the SARFAESI Act and other ARC Act, asset reconstruction companies, because the bad assets, the private banks have started the beginning that sold these bad assets to the reconstruction of companies, asset recovery construction, they sold it. So consequently, the asset reconstruction committee that also failed. So SARFAESI Act is in force, and now because the company is liquidation, because after the liquidation only we used to recover it, that also they changed this IBC process has come into force. This IBC, again the NCLT, National Company Law Tribunal, that has come into force, because there is various options available to the banks now, which they prefer according to the size of the advance and the security available to them, and they go for that modus operandi. So in this line of because now we are going to the bank audits within a short period, when we go to the branch audit, immediately the bankers will say that this is under SARFAESI Act, sir, this is under NPA account that we have given to ARC, sir, this is NPA account we transfer to other branch, sir, SARM branch, sir. Various options available, and they will tell so many things. Because normally, see, some of our friends do not aware of the concepts. What is the SARFAESI Act? Under SARFAESI Act, so if you go for section 8.33 or 14.2, what is 14.1? Like that, some concept we do not aware of it. So that I thought that it is a very appropriate time to introduce the concepts, so make available to our friends so that they can ultimately do the with courageously do the audit of the statutory of the branches. In the light of the all the situation, today I requested Saram Garu, who is having a lot of experience, and immediately he has accepted our invitation. I welcome you, Sir Saram Garu, once again to this webinar. And now, before going for this subject, now I request Andor Sridhar Garu to introduce to today's speaker.
Good evening, sir. Good evening, sir.
చెప్పండి.
Yeah, M.S.N.Sarma Garu is a BCom and BL.
Yes, sir.
Enrolled as an advocate in the year 1978 and in practice up to 1987 in District Courts of Visakhapatnam. Then joined as law officer scale 2 in Andhra Bank in the year 1987. From 1987 to 1990, he worked as a law officer at General Office Visakhapatnam. Since 1990 to 96, he worked as a law officer in the head office, Hyderabad, specialized in legal audit and verification of documents as law officer on behalf of the bank in various high courts. From 1996 to 2001, he worked as a law officer in scale 3 in the zonal office, New Delhi, and worked as a model officer for BAFR and AAIFR, New Delhi, specialized in the representation on the behalf of the bank in the SIC units. From 2001 to 2004, he worked as law officer Hyderabad in Human Resources and General Office. From 2004 to 2011, he worked as law officer General Office Visakhapatnam and Hyderabad. From 2011 to 12, he worked as a law officer in Scale 4 General Office Mumbai and worked as a model officer for CDR in Mumbai. Since 2012, he took voluntary retirement and practicing as an advocate before DRT Visakhapatnam on behalf of the banks and also on behalf of reputed corporate borrowers. He participated as a visiting faculty during the entire service to the staff training colleges of Andhra Bank on the aspects of the claims, documentations, legal audits, etc. And he is a regular visiting faculty to IDBI as well. With these few words, I introduce Sri M.S.N.Sarma Garu to the August Gallery. Over to the chairman, sir.
Thank you, Sridhar Garu, for introducing Saram Garu to the August Gathering. Now, I request Saram Garu to start the session, sir, to take up this session, sir. This floor is yours, sir.
Thank you very much for giving me an opportunity. Good evening, friends. And this topic that was tabled for discussion today is a vast subject. Perhaps Vasudeva Murthy Garu not left any of the corner. He has got a complex way that he has stated that modes of recovery optional to the banks in respect of NPA accounts before the DRT and assets reconstruction companies, NCLTs and SARFAESI Act and SARFAESI Act and LCT and DRTs. And insolvency code too. So let us have, it is a rather, I believe it's not a way of, if I am going to talk to you in an academic way, perhaps it may not inculcate any interest in the matter. Perhaps in a way in which a correct professional, having seen so many things, psychologies of the borrower, psychology of the court, capacity of the borrower, as well as the intention to pay the borrower, but it will, with all this background, I start with the DRT, first DRT. Intentionally, the law believes only two things. The borrower basically categorized as ability to pay and willingness to pay. If he is having a willingness to pay, but not backed by ability to pay, no use. If he is having ability to pay, however, not willing to pay, is the crux of the question. And second thing is the universal defenses available to a borrower are only two. One is denial of the debt and other is the discharge of the debt. So when once an advance set have been given, this is earlier they used to file suits wherever the jurisdiction is there in the civil courts. A chosen few big cases will be there, even given to a civil court, whereby the suits can be filed there itself and a preliminary decree is obtained provided into the mortgage suit, followed by final decree, and the EP has taken care by the bank officials. So the bank is having an access with the borrower either in the court or in the private settlement. When once the advent of the DRT has taken place, what is the difference between the basic civil decree and the DRT decrees? The moment delegation, which resulted in a order of recovery, it will be transferred to the recovery officer. The recovery officer, with his inspectorate, with his recovery inspectors, has to sell the property following the income tax recovery rules. So they basically, the creditor has no right except the state has casted the responsibility on their shoulders. The recovery department, DRT department, has to recover the dues. So when once the recovery starts, the bank is having not a direct access with the issue. It is only the recovery officer who has to set the proclamation, who has to issue the demand notice, who has to visit the property, and who has to conduct the sale, and who has to fix the sale, who has to identify the property. All he has to do. And the present pending of the issues are in the recovery, both in sale. To illustrate, in Visakhapatnam, it is having more than 2,500 or so. And there are two recovery officers. So with what intention the government has framed the DRT were diluted by the overload of the work cast on the shoulders. That is one practical problem. And second thing is, so far as the DRT is concerned, the object of the DRT earlier is only for recovery of the debts above 10 lakhs, subsequently enhanced to 20 lakhs. And now on the IBC code, with regard to the individuals and LLPs was also added to the DRTs. So this is the functioning of the DRTs. So now illustrate Visakhapatnam, DRT is having a jurisdiction right from Visakhapatnam to Nellore of all the nationalized banks and private banks. So the volume of work one cannot imagine there. Volume is there, and then disposal is also likely there because it is an for an expeditious recovery, debt recovery to be given, and the documents, copy of the documents has to be given, and the moment that the documents were given in a summary way by filing an affidavit, the chief manager or manager in charge who can be examined, and the documents we can mark. Possibly because the voluminous documents that has been crept in, because the one has to, because as you are all aware, going with the branches on a number of occasions, what are the documents that require for a 100 crores advance, 50 crores advance will be there. One is, first of all, right from sanction will be there, followed by application will be there, followed by composite agreement will be there, a demand promissory note will be there, a term loan agreement will be there, followed by some what you call title MOTD will be there, memorandum of deposit of title deeds will be there, followed by deposit of title deeds enclosed to that there, and an account statement shall have to be enclosed along with that. These are the vital documents which sets forth for a valid client before the DRT. The question is, if any of these, unfortunately, if any of the documents in the chain set to have been missing due to the technical insolvency, due to the lack of knowledge at the branch level, the bank has to suffer. So the object of giving the trust to the DRT Act only to expedite the recovery, perhaps in the 6 months it has to be concluded. However, in reality, it's not so. The ground reality is otherwise. So then the DRTs, various DRTs are there. The DRTs, the object of the DRT is to recover the amount for the banks in an expeditious way by engaging the various councils. And then this is one of the field which has not attracted the best of the talent in the industries for the low-paid professionals. That's another, we'll talk about. Not the issue is why this particular branch either the NCLTs or DRTs or the has not been attracted by the talented field. Youngsters are not coming to this branch of law because they for own difficulties. So far in the object of the DRT is concerned, one has to 20 lakhs is an original application has to be filed before the debt recovery tribunal, enclosing what all the documents and account statement in a format way, giving the names of the defendants and then securities and other things that has to be given. Basing on that, the OA will be numbered. After that, it will go to the process. After that process, the registrar or the person will record the evidence of the manager and then pass a decree. If it is contested, then it will be contested, and the liable normally cross-examination of the bank officials is an exception, unless and until there is a specific cause that was shown by the defendants that they need to examine the branch manager cross-examination on certain vital points. The court may grant. In these circumstances, once the OA is decreed, then the real problem starts. The OA set to have been given, it will be given to the recovery department where the RC number will be given.
అయిపోయింది సార్ అది డోర్ తీసి ఇస్తాను
శరం గారు అన్మ్యూట్ చేయాలి సార్.
Sir. So, am I audible?
Yeah.
Yeah. So once it has been transferred to the recovery department, RC recovery certificate RP number will be given, recovery proceedings number, where the recovery officer notice again to the borrowers and issue a proclamation of sale as per the income tax recovery rules, and has to visit the property, and then has to have a cost physical verification of the property, and then has put the property to sale and giving a publication and invite biddings, preferably at the site. So these are you are well aware of the income tax recovery rules. This is the basic structure of the RBDD Act. But the ground realities are the SARFAESI Act. Suppose if there are 100 matters are there, the recovery through a recovery officer passing all these hurdles are very bleak. Therefore, it was rightly felt, why can't we have in another piece of legislation to strengthen the recovery? Because that simultaneously the SARFAESI Act came into the force. SARFAESI Act is an act, securitization, assets reconstruction, and enforcement of Security Interest Act. This act basically have two wings in the fold. One is security assets reconstruction. One is as how to be reconstructed the asset, and how the enforcement of security interest has to be enforcement of security interest. That is how to enforce the security interest without the intervention of the court. The basic object of the SARFAESI Act is to say that without intervention of the court, whether the banks can sell away their mortgaged properties. With that object only it came. And earlier under section 68 and 69 TP Act, which to some extent where there is governed by a covenant and it is an English mortgage, the bank without intervention of the court, the mortgagee can do so. However, in a general way, now to give a benefit to the entire community at large, because the courts are facing that why can't the bank can itself sell the properties following the American concept into the consideration, and then they have taken a new act set to have been passed, 2002, Enforcement of Security Interest Act and Assets Reconstruction Act. The salient feature in this act is two. One is how the security interest can be protected, can be rescued, can be reconstituted, can be recharged, or can be sold to an asset reconstruction company, and the management can be given. So how to protect the interest is one fold. If it is not there, then the question switch off to how to sell the security asset. I need not elaborate much because in only housing, small advances, the security will be there. In most of the big advances, you are well aware that these advances are not security oriented. Advances are always viability oriented. Viability, receivables, and everything that has to be taken into the consideration. So once the viability oriented things are there, we'll talk about the very big advances. The security ratio is almost not less than 6 to 7% will be there. Otherwise, it so not happen. You will be surprised to know that there are 12 accounts. First, when they were referred, Bhushan Steels, Lanco Infra, SR Steel, Bhushan Power, Amtech, and ABG Shipyard and Jyoti Infrastructure, and to name 12 of the accounts, constitute 25% of the NPAs of the total banking industry. So whether one can not safely imagine that these mammoth advances shall always covered by 100% of securities. So invariably, banks and financials have to have no security, and then how best they can recover it, they have to recover in the positive way. This is why, because the viability oriented advances, viability oriented are always some checks and balances will be there, board will be there, and then how interestingly that accounts has to be followed. It is a process of the business. So in the Securitization Act, it was taken to the Supreme Court in the Mardia Chemicals case categorically whether the bank having such power, whether the banks can having the judicious authority to sell the properties. If so, under what circumstances the bank has to lead the show is the question. Undoubtedly, the Honorable Supreme Court categorically held that this power can be authorized, exercised by an authorized officer. No, these no other for an expeditious recovery without intervention of the court is only the way, and upheld in the Mardia Chemicals. And equally in the Transcore case also, whether the debt recovery tribunals under the SARFAESI Act can give interim directions is the question. So in the SARFAESI Act, a little transformation from the DRT, where the authorized officer, the bank officer, can directly put the properties to sale if the account is declared an NPA. It is again a Pendra's box, $1,000 question. What is an NPA? What is income recognition and assets reconstruction? What is income recognition? What is a doubtful debt? What is a standard debt? And what is a bad debt? Closing. So doubtful, doubtful, and lost asset. So what are these classifications? How they will make? And what is the NPA when then the debt has not serviced by 3 months successfully? It becomes, when unable to service the debt, at categorically it become an NPA. When once it become an NPA, whether the bank is having a right to revive it after having issued a notice under section 13(2) of the SARFAESI Act, because 32 Act crystallizes the liability and it stands as an injunction against all the properties not to transfer. However, so when once viability, then this is open to him, the borrower, when once I have taken a possession of the property, when once I have taken the possession of the property is the 13(4). 13(4) categorically states about that how the authorized officer has to take the position of the put. This is the most difficult aspect, as we are aware of the professionals, how to take the possession of the property. It is very easy to say that position has to be taken. But what are the difficulties in acting the properties? Normally, in any concept, the borrowers are not prepared to lose the position at all. For that, they are option open to him. They will go to an appeal under section 17 of the SARFAESI Act. See, the object of SARFAESI Act is they have set down certain rules. This is you know that law is certain procedural and law is substantial. In this, they have separated certain rules. The procedural is section 13(2) notice. That is a demand notice has to be given to all the stakeholders, guarantees, borrowers, and mortgagors, and it has to be invariably served. After that, the clock starts from after 60 days. Bank is having a right to take the possession of the property. Possession may be symbolic or possession may be physical. What is the difficulty in taking? It is very easy to say that one can file an application that I have taken the possession, and paper publication, 2 notices will be issued. The law, certain notices 13(4), 13(2), Rule 86 notice, and sale notice. There are 4 important statutory mandatory notices are there in the SARFAESI. Certain notices are required to be served. Certain notices are required to be served, affixed, and published with a statutory framework. So whether the bank is having all the power, whether bank is having the relevant knowledge with the frequent change of the officials from place to the other, one may not have this much concentration either from the file or from the reality. As we are the statutory auditors, the concurrent auditors, I feel it a need, and time and again I say that a SARFAESI audit is required to be introduced. Why SARFAESI audit is required to be introduced? It is totally a technical area where the auditor can certainly point out, look friend, this is not in the file. This is not available in demand notice, is not available in the file. Acknowledgements are not available in the file. When it has not been served, a proper publication is not available in the file. And after that, who has taken the possession? Whether it is a physical possession or it is a symbolic possession. After 7 days, within 7 days, a notice set to have been published in the notice or not. If it is not published, the total proceedings will go back to the stage 1. And if it is filed, and who are the values are obtained? What are the valuations were obtained? And the basic concept is, as you are aware, that at the time of giving an advance, that valuation is always liberal a bit. I'm not commenting like that, but maybe valuation may be liberal at the time of sanction. But unfortunately, within few years, if it comes down for the fixing of the reserve price is concerned, the valuation is almost varies from 20% to 30% low. If sale is not taken place, the sale is not taken place within say for first time or second time, then the question of again further reducing. This is mutually contrary and exclusive concepts need to be explained. So the court will certainly go into the validity of the valuation of the properties as concerned. And so when the steps are not meticulously followed, SARFAESI Act gives a power to the borrower to go to the court and point out the anomalies and ask to struck down the SARFAESI proceedings. One will say that it is a cost, almost no cost proceedings or SARFAESI proceedings. There is a presumption. It is a very less cost remedy, sir. No. So real estate, for 1 lakh or for 10 lakhs of suit, I may have to pay maximum 12,000 rupees court fee in a civil court. For 10 lakhs of rupees housing loan that I may have to recover under the SARFAESI, suppose the demand notice has not been served, I have to publish. The amount required is minimum on par with 20,000 rupees. The possession notice, I have to file in the 2 papers, each 40,000 rupees. And another sale notice, I may have to publish in the paper. That is another 20,000 rupees. If the first sale has not successfully completed, I may have to go repeatedly another one. So the expense will be more than 1 lakh. Unfortunately, this is when once I started the battle, I cannot stop. I invariably, whether debt has serviced or not, whether the person pays the amount or not, invariably I have to debit the account and comply with the statutory requirement of these notices. So it is in our wisdom, the bank has to take whether this is a property. This is a property, whether it can be sold. As you are aware, for selling of a property, marketability, demand, and the reality of the property will be there. To illustrate to a surprise fact, I accompanied with an unauthorized officer to one of the properties. The building cost about that an advance of rupees some 4 crores or 5 crores was given. And to put the sale on the property, to our shocking and surprise, the compound wall of the building and the burial ground are one and the same. So there's a lot of sentiments will be attached to the property. Whether such a properties can be sold, all human psychology has to be played. So far as the realization of the securitization concept concerned. But the balance, the pendulum that have been shifted from DRT Act to the SARFAESI Act is earlier the courts are responsible to recover the amount. Secondly, now the DRTs are responsible to recover the amount in the individual way. Thirdly, slowly was shifted to the shoulders of the banks. Bank seller has to advance the amounts. Bank has to alone recover the amounts. Bank has to stay in the forefront. And what are the problems in getting the physical portion of the property? Physical portion of the property is the property. The problem is way back to the valuation, way back to the legal scrutiny report will go, where the legal scrutiny report at the time that there are certain banks along with the valuer, the branch manager has to physically verify the property and has to certify that he has physically verified the property. So whether the physical verification causes most of the things, most of the problem is In most of the advances, whether you verify big advances and 4 acres, 3 acres of the vacant land in or around a particular place, which is backed by a state deed of a few thousands or 1 lakh of rupees, was under the square yard wise, as if that it was applied for the non-conversion and it will be converted, valuation will be given for an extent of, say, square yard 25,000, 30,000 pieces like that. So if those properties the bank is accepted under the SARFAESI, my apprehension is that the bank purchased the properties upfront. That the property of bank purchased by the bank upfront, with when nobody comes, because now the amended provision is there. If nobody comes, the bank is having a right to bid for the property. So the SARFAESI Act. So the bank may not have an option to purchase this property. So when once nobody comes to purchase the property, bank can bid it. So the marketability of the securities are the most vulnerable securities are vacant urban lands. Vacant urban lands is causing a great hindrance in the recovery, and thereby the paper we may show that the property securities, the advance is well secured. However, in reality, which we are unable to sell the properties for at that price. And in that, there are another 3 problems comes: legal disputes or physical identification, change of the survey numbers, or restriction of the Government Act, section prohibition of the acts. So many set forth of the what you call land disputes or the immobile problems comes when the bank may stuck in trouble. So it is not as if as a heaven's blue when once that you have issued a notice, the coffers will not be filled. It is a burdensome exercise. It is an intelligent exercise. It is a prudent exercise, but the bank has to be taken under the SARFAESI Act. And then the SARFAESI Act, once issue a 13-2 notice, 13-4 notice will be issued, and followed by Rule 8-6 notice will be issued, intending sale notice. After this, 30 days time will be given. After that, you have to a stake can be sold either by way of a private auction, private treaty, or by way of a public auction to come tender bidding. For that, certain agencies are there who are doing it. In reality, my apprehension is this is also a total cumbersome process, where the recovery may be positive, the SARFAESI Act, maybe the positive of the SARFAESI Act, but however, in reality, my problem is I have issued a notice, the borrower will come, and then he'll approach the 17 to the DRT. Invariably, the DRT was kind enough to pass some interim orders asking him to pay 20% or 30%. My account will be blocked. Because I was unable to pay the amount only, I brought the property to sale. The object of the appeal under section 17 is very clear. If I have committed any mistakes in the account, let the tribunal may point out and rectify the defects and then go for the fresh sale. In between that, if the court passes an interim order asking the borrower to pay 10% or 20% and issue a status quo or an injunction not to proceed further in the matter, that will be kept in cold storage. Or he can, suppose he was not given, so the interim order supported by the DRT under the SARFAESI Act was to see whether he is having an inherent capacity to pay the amount. As he is not unable to serve the debt, as he is not having any independent means, I invoked the adjudicating authority and asked him to pay the amount. Ask him to pay the amount of 10% or 20% of the show. Where he will bring is the practical question. So invariably that will fail. Because of the clause, the fails to pay the amount, the bank is at liberty to proceed further. And here the third question is how to sell the property to the SARFAESI Act. Whether there is any established organizing agencies are there to mobilize the bidders, or just like that, if it is given a paper, 100 people will come like first show for the Chiranjeevi's movie. Is it so much of demand is there in the market? And thousands of properties day in and day out have been published in the banks. Whether all the properties are being turned into a virtual sale reality, this has required to be addressed. Unfortunately, this is having a prison, someone's pigeonhole block of the apartment. One person is doing, other people are not doing that. So in the SARFAESI Act, these are the practical problems one should have. And then if you issue a sale certificate, suppose by good or bad, I put the property of 10 crores for sale, and some other third party has purchased it, having seen. There are number of problems of SARFAESI property has said to have been purchased. If there is a problem of the stay, I sold the property. Again, the borrower will come and obtain the stay. Then the position of the bank, then the torture will be on twice, two sides from the bank. One is from the borrower, other is from the purchaser. The purchaser clandestinely knocks the door of the branch every day. And what happened to mine? And then the law is very much settled unless that the third party purchaser has included as a necessary party to the proceedings, court cannot decide it. So if I purchase a property, even assuming for a moment in the SARFAESI Act, if any SARFAESI proceedings have been initiated by the borrower, what I have to do is I have to go to the court, engage an advocate, and implead myself as the party. Suppose I have been included there. What the defense I will have? I have no defense other than the authorized officer defense. If the authorized officer, the court is satisfied, if the authorized officer has followed all the statutory steps meticulously without any deviation, diversion, then the court will pass the sale. Otherwise, it fails the sale and go back to the work stage one. In those circumstances, how I can face the purchaser? Purchaser will be very arrogant. He will be very vexatious way. In a way, he will come and then say, and then they will say, but unfortunately, then we will see the bank will issue a sale notice. The property will be sold on as is varies, what is varies, their condition. On as is varies, what is basis condition means that relates to the mobiles. So far as the property is concerned, immobile property is concerned, you have having a valuation report, you are having a legal opinion. That's of course that the purchaser has to say that. That way, the court said the rule of caveat emptor will also apply, and he has to cause the physical verification. He has to see the records, and it will be examined for exhibition of the property as well as the documents to the purchaser. But he can do so, and he can do so at his own risk and responsibility. So then when once I am selling a property, invoking the statutory provisions as an authorized officer, my responsibility is doubled. So in the SARFAESI Act, the total responsibility rests with the authorized officer. Authorized officer has to consult the committee that has to be constituted journal office committee or some other committee wherever they the credit department and some other people will be there, GGM or GM, whatever may be the group. They will take a decision, go to the reduction of the price and with regard to the availability of the securities. And in between these two, the whole problem is easementary rights, passage rights, access to the sites. These are all the things, in fact, are not earlier addressed. These are by experience, turn the page and learn the work we are experiencing. And really, when the property is put to auction, these are the problems we are coming. These are the problems we are facing. Certain plots, open plots are not backed by waste, and certain plots are totally no waste except the piece of land in or around that totally locked on both the sides. If I can sell the property, I must show the way. So all the properties that were mortgaged are not sellable for the reason. If they are not sellable, what is the way in which we can do? Then we have to switch to the other mode. Because the borrower, this is a psychological game. The borrower is having an intention to clear the debt and wash his hands by paying some money or the other. He will bring a third party and allow him for a private sale. Suppose to go for a private sale, there are the clear instructions from all the bank, unless and until the sale successfully failed for 2 times, on the 3rd time you cannot go for a private sale, private treaty. Private treaty will be there. So the authorized officer has to conduct this failed to be successfully for 2 or 3 occasions, and ultimately he may have switched over to the private treaty. If the borrower intends to bring any party per se. So that is the position of the securities. And another important thing in this securities includes both mobile and immobile. So far as the hypothecated mobiles is concerned, that is the vague area where nobody thought of that anything we can do. Stocks. Suppose a big industrial unit is there where term loans were given to a heavy extent, backed by heavy machinery. And a list of machinery then units taken, the authorized officer can take the mobiles of the machinery. The whole problem is how to sell the machinery is not at all, there was not set forth any mobile machinery, agencies are not there. How can sell the property? You believe it, this is a cliffhanger, sir. If it is on the hanger, it cost me 8,000 rupees. Just if it's stripped off from the robo and placed on the what you call on the roadside, it may not fetch even 200 rupees. The place that has to be there, the correct person has to be purchased, has to be there. So mobile machinery problem is mobile machinery, hypothecated mobile machinery is the selling of the highest problem. So before selling up all the properties, bank can take vigilantly how to deal with the hypothecated machinery first. Hypothecated machinery, if you can sell successfully, bank is successful in doing the 50% of the business. Because otherwise, the land cannot be sold. Land planted machinery is there. Suppose a very big rice mill advance is there, say 100 crores. Stocks in trade are there. Stock statements are there. They do not always the stock statements which we going for an inspection or available stocks may not be available there. So stock in trade, finished goods, but has to be first addressed. Then alone one has to come to the things. And secondly thing in our wisdom, suppose if my loan is some 20 lakhs, suppose I'm having two properties. One property which 50 lakhs and another property fetches about say 4 crores. One property we put it for sufficient, but all the properties you put in a single basket and wants to sell the show. Ultimately, though you are having a right, but ultimately we fail. Ultimately we will fail. Those stocks in trade has to be addressed first, and hypothecation of goods has to be addressed first. And then another important thing, it is if it is a big ongoing organization, if ongoing business concern is there, I am having trade creditors, equally trade debtors. Trade debtors also will be there for me. Suppose I am doing a rice mill business, I owe 100 crores or 10 crores to banks and financial institutions. My trade debts will be there substantially some 20 crores or 25 crores, where the purchase out by whom I have supplied, they have to give me. The moment this SARFAESI notice is issued, the moment the NPA is classified, you must assure that no trade debtor will honor their commitment to the borrower. Will never honor to the commitment to the borrower. This is one gray area. First of all, so if the trade creditors are there, if you give him an opportunity first to the borrower, stand besides the borrower and take him to recourse to recover the amount first from the trade borrowers, and then can you go ahead. Unfortunately, you are doing two things. You are by putting a SARFAESI notice to an ongoing concern or a trade where your balance sheet of the creditors shows that the trade debtor, you sufficiently ignored the trade debtors. They will not pay. Let me illustrate, medical colleges we are seizing, government colleges we are seizing. What for the security? And then so much receivables are there for the colleges and they are fighting. The moment the SARFAESI notice is there, they will not pay. So he will be sandwiched in between. That is, the borrower has no moral right to claim back the amount from his borrower, our borrower, and equally he cannot have a show face here to pay. And the securities what we are taking, that has also to be viewed very seriously. The financial issue. Suppose if I take a very big hospital and advance an against rupees 200 or 300 crores, ultimately whether I am having an expertise to run the unit, or whether I can sell an education institution, or whether I can sell an hospital. Amounts advanced to the corporate hospitals. So the recovery in that is, first of all, we could make a mind, recovery is always linked to the change of the management. Recovery always linked to the conversion of debt into equity. Recovery always linked to the some other process. Just right away that I cannot sell the property as if I can put a note on the 500 rupees note and obtain a change for 500 rupees. I cannot liquidate the property in such a way. This is a gross reality. One is always aware of that. This is the problem. So far as the securities are concerned, housing loans, then this securitization, when once you are having a security, when it is having a tradable security, it is a tradable security in the sense that you should have a power to sell the property. If it is the midst of Visakhapatnam, very big property is there, 1,000 buyers will come and purchase the property. Whereas if a property is too remotely connected, nowhere is there, and no buyers will come, except the valuation will say so. However, in reality, the recovery is perhaps the SARFAESI Act may not be possible in the near extent. So the third option that they have taken is how far I can go for OTS. This is also this is another new concept of OTS, one-time settlement. One-time settlement. The problem is that the value of the securities, today's money, value of the tomorrow. Suppose the debt is say 10 crores, and the party offered me 3 crores or 4 crores. What is my wisdom in accepting the one-time settlement? The one is, if I have to recover these 10 crores or part of the amount, I may have to wait for some 7 to 8 years or so. Suppose if I receive this amount just well before it, the cost of the amount that has to be worked out, that has to be taken tomorrow's value of the money, and I can get rid of the litigation. I can successfully claim the reversal of my provisions has to be made, which is in the balance sheet earlier. So this ought to be worked out, amount required to be written off and amount required to be waived is a credit decision that has to be taken by the various levels as per the powers that has been conferred on the bank authorities. So the OTS concept is one, and selling of the properties two, and SARFAESI properties, selling the properties is third one. So when once this property is sold, I have to issue a sales certificate to the borrower. It has to be registered, and for the balance amount, I may have to recover. In gross, when you because here the literacy concept of the borrower is we have to understand. We will go for a stay is a stay. Bank will have bank will debit the interest continuously, and there is no stoppage for the rent unless stoppage of interest, claiming interest, unless either the account is closed or set you have been recovered. So the question of recovery, stoppage of OTS is one way. Selling the properties in the SARFAESI is the other way. And these are the practical hurdles that one should aware under the SARFAESI Act. And then comes to, after the DRT and SARFAESI that I have taken that, and I would like to take you to the Insolvency Act. Insolvency IBC Code, Insolvency and Bankruptcy Code of 2016, subsequently amended to 2021. Insolvency, bankruptcy are two different concepts. Insolvency is a state of financial distress when a person no longer to pay his dues. That is, insolvency is temporary. Bankruptcy is the end of insolvency. It is a legal declaration. Liquidation is a closure or winding up the company by selling the assets. These are the basic things. Just before we start the IBC code, we should bear in mind. Insolvency is a state of mind. Application is a state of shame affair in the society. But due to the change of circumstances, declaring insolvent, inability to pay the debts because of the various reasons due to the pandemic, because of the no market for production and no market for consumption, and state aware of the state changing policies and export hurdles. Suppose if I have stayed at LC2 and you export to Ukraine, there are no circumstances, mismatches, force clauses, so many things that have been, there are so many contributory factors to become an insolvent. To become an insolvent is not a shame henceforth. That has to be the view of the society that have been changed. And insolvency fails, and you will not revert back from the insolvency to the regular way. Ultimately, the liquid is that. Bankruptcy will be declared. The legal declaration of insolvency is bankruptcy. And when you become a bankrupt, the liquidation process will come. The creditors will sell their properties. The creditors automatically will sell their properties, and then what are the available, they distribute it. The object of the IBC code is for us for ease of doing business, because the mounting of NPA ACs have been as at 9 to 10% of the total advances. They say from 2,500 lakhs to 3 lakhs crores of there. From a brief economic study reveals that. So how to tackle the problem is big question. Now, earlier we have seen Earlier we have seen the NPA borrowers. Tomorrow there is no surprise. We may see NPA banks. The reason will be that's why the liquidation and mergers that has taken place and the capital adequacy ratio set to have not been maintained, and the recycling of the funds may not be possible. Therefore, we have seen so many banks are there earlier in the doldrums. So the recovery process is an inevitable thing for a bank or a financial institution concerned. How best we can show that? Earlier, evading is an exception. Payment is a rule. But now the issue is otherwise. Payment may be regular borrowers is an exception. Evading became a rule. Otherwise, this much of accounts we have not taken place earlier. The mammoth thing. This is a thing that has to be all our brains in the society as being the very, very advanced people who are responsible for the public money, as the chartered accountants, the advocates, and society at large must think twice what is going on. Why? Because it's a social responsibility to recover the amount, because the public influence, confidence, the moment evades, banks will go. Banks are supporting. And whether under the banks now, this is so a new concept of technology set have been, a new concept of science training has to be required to tackle this mammoth situation. For recovery under the SARFAESI Act or recovery under the DRT Act or IBC code, that's so many things that has to be taken place. That way the resolution professionals, the chartered accountants are being appointed having more than 10 years experience. Whether the resolution professionals, what are their backgrounds? Because an RP comes and asks to run a pharmaceutical industry, can he do so? Whether that expertise is there. Can a resolution professional ask you to run a medical college, can you do so? So just because appointing the change of the in the place of the management, a recovery professional, a RP, a resolution professional may not be a best answer unless he is sufficiently backed by a thorough man, well versed either from the management or from the bank, can do so. Suppose if I ask you to run a 1 lakh poultry unit by the resolution professional from tomorrow onwards, I do not know the difference between a chicken and a hen. So this is the issue that has to be, this is the practical way that one has to be taken in mind. And financial, who can move the issue is, okay, you have set forth the insolvency and bankruptcy code with a very, very good object of to liquidate the debts, to put an end to the debt. And then in that, who can move an application before the things? The adjudicating authority, NCLT or NCLAT appellate authority. One is the financial creditor can move. Second one is operational creditor can move. Third one is the borrower can move. And then this is, so far as the corporate insolvency is concerned, the adjudicating authority is NCLT. And so far as the liability individuals and liability partnership, the adjudicating authority is DRT. Suppose what are the steps I would like to say, how best it can come. Just let you know the steps first before. I'll take you to the steps of the first. If there is a default, then this default starts. One has to move an application before the NCLT, and within 14 days, if the NCLT satisfies that there is a room for adjudication of this bankruptcy application, insolvency application, they can appoint a resolution professional. Has been a resolution professionals is there now. A resolution professional will appoint a committee of creditors, and a committee of creditors will prepare and approve a resolution plan, how to address the resolution. 75% of the by volume or by members who has having a right of voting can approve the resolution. When the resolution is approved, it is placed before the NCLT for final adjudication. And then in case the resolution is not been accepted, there is no other go, one for the liquidation. So in this, this is the basic so far as concerned. And then I would like to now put for our thing two important things. One is corporate insolvency resolution, and other is the pre-packed insolvency resolution. Pre-packed insolvency resolution. So, pre-packed insolvency resolution and corporate packed insolvency, CPRP and DIFRP. So, this PRC, pre-packed resolution, pre-packed insolvency resolution, and corporate insolvency resolution process. One is a CARP will be filed by the company, and pre-packed insolvency process will be submitted by the borrower. What are the advantages are there in pre-packed insolvency resolution? How it can address the difficulties that have been just now we have discussed in the SARFAESI and DRT. How it can help in between because earlier the total is earlier in the insolvency proceedings in the Provincial Insolvency Act or Provincial Insolvency Act or certain provisions are there in the SICA, Sick Industrial Undertaking Act, or what you call the Sick Undertaking Act and Companies Act 1953, 56 and other Companies Act. There are certain provisions speak about the resolution, but to call a unified code, IBC codes that you have been there. Code is different from an act. Why? Because the act may be there, in that certain rules and regulations may not be there. But IBC code is a procedural code where inherently it contains the rules and regulations. That's why it is called as an IBC code. So, and then just we will have pre-packed insolvency resolution process. Why it is helpful to the individual borrowers of the company, let us say. In this, earlier, the management in the default, in the lending, when once the insolvency is there, it has been with only the borrower. And in the important thing is in the IBC code, the shift of the possession of the management was shifted to the creditor. When the PRC, with the pre-packed insolvency resolution process, is a combination of both. Because a pre-packed resolution process, suppose I am having a 100 crores industry, I could not say so. My DRT goes, it will not work out. And if I go to this, what you call the SARFAESI Act, it may not fetch. Suppose in the pre-packed resolution process, I can have a pre-packed resolution plan, sit with the creditors, and then can place it for consideration and then approval. Because in the pre-packed resolution process, because I have given it, I am having a say along with the management, I mean, along the creditors, along with the creditors. And then I can say, sir, these are my workout plan, these are my receivables, this is my value of the machinery, this is the things that I can bring the amount, this is the amount which can require the debt to be converted into the equity, this is the debt required to be either it can be converted into a funded interest rate term loan or a funded loan which is repayable for a certain time, or these are the additional things that I will bring in. This is the amount, these are the interesting third party purchase, third party interesting investors are there. So these all the things comprehensively by looked by both the people, and the PRP can be validly worked out. This is the most acceptable solution, because in the SARFAESI, the borrower bank cannot turn up, and in the what you call in the DRT is impossible to turn up. A quick resolution process is pre-packed insurance resolution process is a worth considering, because in this the borrower once again will be given an opportunity to share his to bet for his good, to invite the creditors and secure the confidence, and more than 60% of the creditors do agree that pre-packed resolution process may go. Any selling of the properties either in the resolution, either in the liquidation or the SARFAESI Act are one and the same. If you have sell the properties as the liquidation or the SARFAESI Act, it may not have any impact. So in the pre-packed resolution process, in the corporate process, because it having a consensus between the borrower and as well as the creditors can come on a single platform, and an RP will come, and then accordingly this process will be there, RP will be there. All the people can comfortably work out, and they can fizzle out from the difficulty. They can bail out from the difficulties concerned. They can certainly bail out from the difficulty on the corporate resolution process and change. And the third thing I want to put you, what is the another important thing is why because here when once nobody knows, SARFAESI notice issued, it's a time-bound program, 13.2, 13.4, Rule 8691, and it will go on and then goes with the post. But the PRP is interesting thing is a time-bound program. All the 170 days, 180 plus 90, maximum 270 days is the higher side that has given. But here, the most important thing is that the borrower is having a moratorium, that he will be protected from the other legal steps that has been taken by the other financial creditors. So he will be given a cushion and comfort. Therefore, under these circumstances, the moratorium is there, that he can be very can think of very well. He can think of for the better conducting of the businesses concerned under the prepackaged insolvency resolution process. So for the corporate insolvency resolution process, a committee of creditors will be there, and the committee of creditors will be put on voting, and then he will give it to. The reality is each and every account has a distinct character, a distinct viable thing. A thorough homework has to be done so far as any big account is concerned. A thorough homework has to be required. And then when it comes to our Vasudeva Murthy suggested, when we go for a statutory audit or a concurrent audit, people will confuse the things. Sir, this is given to ARC. What is an ARC? Assets Reconstruction Company. When it is registered under when it is SARFAESI Act, Assets Reconstruction Company is registered, the company is having a right to purchase the assets in a basket from the bank, and they step into the shoes of the bank and they recover the amount. Yes, as if the bank cannot do that, the assets reconstruction companies are formed to purchase the properties, and then they have done it. And in fact, in certain things, dealing with the ARCs is because dealing with the ARCs is a bit business-wise comfortable for the borrower. The reason is, suppose if I owe 100 crores to a bank, if they sell it the property, they sell in block for to an asset reconstruction company for 60 crores, and assets reconstruction company, if I can pay 65 crores or 70 crores, they are comfortably, they close the OTS, whereas the bank cannot do that. So the in between the ARCs has given a lot of comfort for the genuine borrowers to pay, having a reasonable cut. So that is the object of the ARCs come into the force, and then they are the object of ARCs is they are specialized in recovery, because as you said, if we were given 100 crores account, what are the things that has to be required to be looked into? That is the motto, that is the object. Just like that, without knowing the fact, just like it is knowing the fact, just I have opened the SARFAESI, I have opened the DRT, I have opened the IBC. All the weapons that I have opened it is just like a blind man watching for a black cat in the dark night. Unfortunately, that is the issue. I cannot say. So what is the remedy? What is the medicine? What is the step that has to be taken by the bank and the prudential auditors and the advocates? What is the thing that has to be taken? It is a scientific proposition, and it is not a litigation. It is not a litigation, it is a curing. It is a curing of the things. How best we can do that? How best we can do that? Suppose if a poultry of some 60 crores is become an advance, and then the salient branch is there in or around another bank, another branch is there. One can go and then ask him to take away this. Provide me, I will give an advance. And then another thing is, suppose if any purchases are there, I think there are certain things purchasing the surface assets, some banks are not advancing. The question is, suppose my question is, when once you yourselves are not willing to advance to a property purchased sold by the bank, who else will do that? What is the wrong in that? If you are having satisfied with that, and then he can successfully change the management, he can successfully run the business. If the bank cannot comes to the stage of the advance of the second innings, the first innings will automatically collapse. If you yourselves don't trust him, if you are not going to trust the purchaser who has reasonably invested some part of the money for purchase a SARFAESI unit, and then wants to give an advance either by way of working capital or a term loan or by way of some other funded or non-funded liabilities, who will come to the rescue? So once a mortgage, always a mortgage. Once a NPA account is not always an NPA account. Once is not always an NPA account. There is a chance of survival is there. Though one has to inculcate that much of confidence. Otherwise, blindly 100 banks, 2,000 assets put in the process, day in and day out, flooding the newspapers with the sale notices. Is there any reality? Is there any information available under the Right to Information Act? What is this? What is the percentage of the properties sold under the SARFAESI after giving the sale notices? Is there any data available there? If the data exposes, the Pandora's box will be opened. So in all its reality, according to me, unless this is a curative science, not a detrimental to the borrower that I could sell. If it is 100, if it is a 20 crores, if it is a 20 lakhs housing advance, if it is an apartment, he can have anything. Even that also, if any property comes, it will be sold. But the data is available. What is the expenditure that the banks truly incurred for the prosecution of the SARFAESI proceedings right from the beginning for an account wise? And what is the cost analysis to that extent? What is the amounts that you have been debited to the account? What is the chance of recovery of those amounts has to be worked out? Because as we are the prudent people, we must suggest the organization why you should show the good money against the bad money. You will not going to recover. Whether there is before going on hand, before on going any hand, all the mortgage properties placed on the table before the committee and then have an assessment 1, 2, 3, 4, whether it's having a marketability, whether it's having good title deeds, whether this property has not been backed by any encumbrances, whether the property is having all the clear and acceptable verdicts. If so, whether to whom we have to entrust this property for homework, to have a preliminary inquiry about who is going to purchase the property, whether you are having any 3 people, 4 people names on your head. If that was not there, if you are given this advertisement and sale of the property, and you are given to one Bombay agency to sell it on the online platform, that person do not know the property, that person know not the property, and then here machines won't work. Men should work. Men should work in the property selling. How can you say, how can you imagine that a person sitting elsewhere in the Bombay can conduct an auction for the property in Visakhapatnam? Neither he sees the property, nor having any view of the property, nor the authorized officer having any say in the property. If it is sold, it is just like throwing a pin in a sea and then searching for it. We'll do also. Unfortunately, this has to be practically viewed. This has to be practically checked. These are the practical hurdles under the SARFAESI Act and the DRT Act and the IBC code is concerned. And say certain things, interesting things I want to part. That is in the bank code, and then the object of the IBC code, insolvency banking code 266, is to improve the handling of conflicts between the creditors and debtors. This is what we have talked about. This is handling of conflicts between the creditors and debtors. And there is a well-planned mediation, a well-paid agency. About the chartered accountants are there, other retired judges are there. So there is some bridging before doing all these things, there must be a fruitful conciliation efforts between the bank and the borrowers has to be taken. What is the practical difficulty is the borrower is there. Suppose a power trading company is there, where having receivables are there. Suppose our receivables were siphoned. If that's siphoned, then the question of money laundering will come. Whether the forensic audits that have been taken place under those circumstances, whether the IBC code will apply, whether this will allow the change of management is concerned. This is the another vital aspect. This is the dark side of the game. This is the dark side of the game. Suppose if one can address legitimately the act against an honest, paying, resourceful, inherently possessed with the business, some amount can be referred. Whereas a 2,000 crores of advance that has been taken place, for which that was not a security oriented, and it has taken phase wise, and multiplicity of the things were there, amounts were siphoned off, and then one man declared, and then CBI is registered, enforcement directorate comes, and assets that have been taken place. And what is the object? That is, initially one has to arrest at the beginning. Suppose I am having a 100 crores CC limit, without having anything that I am passing the things that some 10 crores or 20 crores was purchased for a property for a speculation basis. The property will be there, but the working capital will go, and automatically the account becomes sick. Those are the major concerns initially. So when once the account become bad, when once the account going to go for a SARFAESI or IBC code or DRT, the reasons for the failure of the vital. The reasons for the failure of the vital in the sense, there are two things: whether he is an honest borrower, if he is having any properties, bring him. bring on a table, sit with them, avoid the legitimate and apprehensions of the bankers that they will be unlessly cornered if the compromise is accepted, or so one has to go in a positive way. One has to go think in a positive way and can have to do these issues. Ultimately, if you are not going to do, this will happen. Suppose if you are a 10 crores advance, you have failed to pay at a time when once strike the iron where it is in heat. When the borrower at the initial stage, if the 10 crores you have knocked the door at the first time, he will make an honest attempt either to pay some 5 crores or 4 crores. Then issue is, what is his way of raising funds? The bank must initially say, suppose, sir, if I am having a property that was mortgaged to you, say 4 crores, if I can sell the property, it will fetch, say 4 crores. As you are aware, certain transactions will be there. He will be benefited. 4 crores he will pay to the bank, and bank will hand over the document to him. You can recover the amount, and then it can be processed and it will be a tool, a working tool for process of compromise. Suppose if I given a 10 crores advance is there, my settlement is appeared for 8 crores. The bank will say, what is my source of funds? I can proudly say, I can sell the properties with your consent and remit the amounts to you. Is there any wrong for the bank to accept that? Is there any wrong to accept that proposition? If it is not accepted, what will be the next fallout? Compromise will never be accepted. The properties you will put to sale, and he will some unfortunate elements will be crept into the consideration because of the illiteracy or because of the spontaneous temperaments. He will go to the court and he will book the block in litigation. And the cost of the litigation is twofold. One is a cost of litigation for the bank side is an orphan litigation. It's an orphan litigation so far as the bank side is concerned. I repeat, the reason will be the authorized officer will change from time to time, and the banks will be merged depending upon the amalgamation process will take place, and subsequently these accounts will be transferred to one consolidated assets reconstruction branch, where the knowledge of the account will be diluted, and ultimately one has to see the my assets reconstruction company will be there. My account is there in the asset reconstruction company, and some other people have approached the bank for fresh limits also, because there is a lot of communication dropout. There is a lack of communication vacuum. So the first the bank in wisdom has to do is, when once for a coupled compromises, one-time settlement coupled with selling of the properties, mortgage to the bank is a happy phenomenon. Or pre-packed insurance process is a happy phenomenon. Initially, you have to these two you have to work out. Just now giving a notice for the inspection department or by the authorities do not serve any purpose. Do not serve any purpose. So this is easy to talk about and very hard to digest. In the sense, it is very easy to talk and hard to digest. These are the practical difficulties. As I worked as an in-house solicitor of a nationalized bank for 25 years, and more than 20 years I am in the field of the specialized recovery of the banks, and for a chosen few of the selective corporate borrowers. I have seen the brains of both these friends, and then come to a fundamental conclusion. Unless there is a good talk, a dialogue between the bank and the borrower, more than 60% of the accounts will come without passing of these all hardest results. Because we must assess the gray areas that are required to be addressed time and again is hypothecation of stocks, receivables, machinery. Unless these three things in an ongoing organization have addressed, has no meaning. And banks also must be aware of the fact that whatever the security that was there in crores on the valuation of the table or on the files may not be translated into cash. The reason will be majority of the properties are untradable. How can I sell hospitals? How can I sell education institutions? To whom I have to sell? Suppose if the education institution have given it, say 50 crores, in that 30 crores or 35 crores are labs and computers. So if I can just throw them all out and then put the property, the 30 crores value of the computer, the mobile asset, that will go to dogs. I'm sorry. Is it not? Is it not painstaking? So a prudent and worthyful creditor must address all these things, make it in mind. This is the actually, but once, because the fundamental, both in the IBC code or in the SARFAESI Act or in the DRT Act, mind you friends, the adjudicating authority is the bank. There is no separate adjudicating authority. I am the financer. I am the judge. I have to recover. Karta karma kriya nade. So under these circumstances, we should have a visible concept of thinking. How to address this issue is the vital amount, over as the recovery of these three things are concerned. And the amount of depreciations, the amount of practical hurdles that has been taken place in all these recovery, these are all the recovery tools, IBC code or DRT or SARFAESI or SARFAESI Act or DRT and IBC code. They're all the venues that has been wide open to the venues, giving a wide opportunities of the platforms for the creditors and borrowers to think about wisely and to recover the amount. Think wisely and recover the amount is an answer. Unfortunately, if it is not being visualized, if it is not a trial and error basis, because a trial and error basis means I have to issue the SARFAESI notice, it will fail. I have to go to the DRT, I will obtain a decree. A decree will be not executed by the recovery officer because of the things, and I will go to ultimately creditors insolvency process. I will go. A creditors insolvency process, resolution professional will be appointed, and the resolution professional will incur certain costs, and then ultimately what I said, that the cliffhanger shirt of 6,000 rupees was sold to 600 rupees or 60 rupees on a platform. That is the fate of the and in the process of time, we should acknowledge the psychology and mentality of the borrower. That's more important. The psychology, the mentality of the borrower is at one point of time resources, because litigating costs for the is very high. So if I ask you to go for a DRT or against a borrower has to go to the DRT, has to pay the fees, DRAT has to pay the fee, High Court has to pay the fee, NCLT has to go, everything, amount he will, then ultimately he will switch on to a mental conclusion. Suppose my unit is 100 crores, I lost the unit, I'm having a ready hand of money, something or shoes stolen or hidden or something, I'm having some 4 or 5 crores with me. Is it wise to spend this money in the legal battle and have to fight with the bank, or leave the corpus to the orphans? Then the whole problem will come. Then it is an abandoned property, uncared property, unchallenged property, undisputed property. Then ultimately the liability of the bank is double. In the process of time, here the officers will change, that man will be there, and in the meantime he lost the interest for the settling of the property. And then unfortunately there is no stoppage. Today this amount said to have been say 50 crores, and then 3 years, as you know, 16%, 2% penal interest, anything not recovered will be loaded to an undebited interest that comes to another 50 crores. So 50 plus 50, 100 crores. Then this compromise proposal said to have been fortunately tabled with 25 crores or 30 crores. The sacrifice is required to be 70 crores. Any prudential public servant who is discharging the duties under the public sector bank, I think so that he may not dare enough to take any proposition positively. So this is something. Suppose if you have gone to an NPA, where is the need for loading an undebited interest? Is never earned. It never has recovered. This concept of loading an undebited interest after the declaration of the NPA at the time of compromise is something putting a rope to my legs, or putting a cloth before my mouth to speak about. This is a serious concern. So everybody say that you should compromise. Everybody say you should go for ODS. Everybody say you have to recover the amount. Everybody say that you sell the property. Everybody will say that you can go to the DRT, SARFAESI or IBC code. It is the boss of the verdict of the great authorities. But unfortunately, nobody is having a touch. There is no qualified things that are available in the market. Just you are having a disease, but you are not having a medicine. You are having a disease, you are not having a medicine. What is the medicine that you are having? 3 medicines. You have to suggest one by one, clear and error process. If one thing cures, there. So ultimately, the recovery philosophy has turned to an extent. If the borrower, by any chance, comes to a conclusion, pays the amount, that is a recovery. That recovery, all the institutions will show it's a recovery as if it has recovered under their skill and pressure. So, in reality, if we can go for in fact, it's a research subject. It's a research subject in the finance. So, what to do? This to focus the attention in a syllabus way, train the professionals, act as the mediators, put them under a separate cell, and then give sufficient training, put them into action, and then do it. Now, can I say, when the SARFAESI is a private act, private resolution is almost a private act by the creditors and borrowers with the consciences, where the judicial intervention is very limited. Why can't the banks or the financials have an internal, like internal ombudsman, an internal mechanism of the recovery? Having a recovery branch, put them some 2 or 3 officers is not an answer. Do you have a skilled people? Suppose I have seized a unit of a power generating unit. Do you have a power generating unit? What is the things fundamentally? Common sense is law. Who is the competent persons to purchase? What are the receivables of my borrower? Why they have not received? Whether they can come for a resolution, whether they are having an arbitration proceedings pending, what the chance of recovery? If I can invest in the arbitration proceedings, whether I can wait for something, or whether who was there to purchase it, and who are there to invest some money in this, and rest of the amount, how can it be advanced? So the greatest bills these are the things that has to be worked out everywhere. And you are aware, the consortium lending is also a big process. Consortium lending always follow the leader follows the members, and nobody leads to nowhere. That is the consortium advances. Consortium advances, according to me, brought into pressure into the existence is very big advances, the myth. Suppose State Bank of India advanced 100 crores. If any other bank follows the suit, his young brother, another advanced another 15 crores. Just because what are the precautions that has taken? I may be excluded from my responsibility and liability. Is no. Consortium advance is basically to fill the needs of the borrower in a higher advance best. Just because one big brother has given, I followed the suit without following the norms, say no. Say no. So whether then first, just because 90 days, first you have to identify it when it comes. So 90 days, after that 90 days, take another 60 days, study the account thoroughly, inculcate, bring all the legitimate professionals on a table. Just not 91th day, don't issue an NPA notice. And the NPA notice issue, no sir, these 60 days is useful for me to study the weaknesses and strength of the borrower, to study the weaknesses and strengths of the asset, to study the strength and weakness of the ongoing business, to study the weaknesses of the change of management, or to convert some part of the debt into an equity, or to initiate the legal action about the possible genuine trade debtors. So to bring all these things to a conclusive thing, then alone to use either DRT or SARFAESI or IBC code, whatever it may be. But without considering all these things, without considering all the venues open for an open discussion, for a wide range speculation, or choose and error basis or trial and error basis, if these remedies are pursued to service, because banks may be at loss. Banks may be at loss. The reason will be it is the way in which one has to tackle the problem is from the debtor's angle, definitely not from the creditor's angle. Because if you address the problem from the debtor's angle, you find a solution. If you address the problem from the creditor's angle, you will be a problem. Ultimately, that end has not worked out. You are having your own ends. The peace is not there. War is inevitable. War is inevitable. So we have to advise in our wisdom. So these things has to be taken out by way of in a complex, a clear document before the bank is concerned. But the accountability study will be there, reasons will be there. That's all over. But now the moment the account is proposed to be declared as an NPA, banks now take as sufficient cushion of another 60 days. Other not, and then has to take any action. These 60 days will be reserved for the bank to address certain things. One is dialogue, and other is identification of the property. Next, identification of the investor, identification of the similar people who are engaged in the trade, and number 4, identification of the properties really there, or whether it has been any vigilance angle is there, whether the properties are there in existence, or whether the properties are rightly traceable, whether the properties are rightly verified, all the statutory permissions are there available for the property, whether it is a land acquisition, whether the land is there, whether the conversion is there, or it still remains an agricultural property, or whether all the records are there, whether proper entries are there in the revenue records, whether borrower's name is properly incorporated, first things to be taken. So this is the investigation of the properties is concerned. And then comes to the, as you write, repeatedly I am saying that about the independently that we have to carve out the machinery from the plant, and who are their ready purchasers are there in the market. Is there any similar banks financing this sort of business for the similar? Because if you can convince them to take the business, it is double fold. One is the borrower gets the prospective borrower gets the machinery at a cheaper cost, and the bank also can successfully get rid of their machinery for a reasonable cost. That is to the advantage of the borrower. Whether any banks are doing that? The banks are doing that? No. In all its perspective, whether any problem that had been addressed by the banks to take care of the hypothecated machinery. The another problem is unless you have taken care of the moment you have taken the inventory of the hypothecated machinery, that you have to insure it, you have to safeguard it. So it's a onerous obligation on part of the bank. So the bank should make a note of that they should positively first sell the hypothecated machinery, sell the hypothecated stocks, take the venture of the receivables that has to be available with the borrower. You all the three address it, and then come back to the available securities that are available with them. Unfortunately, issue is not there. If you can straight away go with the selling of the properties, put the property to sale, you are not going to address all these things. Ultimately, where are we? The recovery process, according to me, has to be addressed in the way the recovery process, not to please the people who are sitting at the top that we have done it. In fact, nothing has been done out. Issuing a 13D notice, 13-4 notice is not an answer. So the remedies that are available pocket in the bank, the 4 has to be chosen selectively, has to be chosen wisely, has not to be chosen simultaneously, has to be chosen one to the exclusion of the other, one to the exclusion of the other. And this is a science. This is a science where the leading experienced bank professionals and other qualified professionals, other stakeholders are all to be into a code and then have to address one by one. So the recovery is a science. It is not a threat. It is not a threat. Recovery is a science, a skillful exercise, a prudent, skillful, burdensome exercise. So under these circumstances, the recovery has to be taken in mind by the banks in such a way that to be taken one after the other, thinking wisely twice before the pressing the same into service. So, friends, I am very grateful for providing me a noble opportunity to speak with my co-professionals on the other side of the financial professionals on this subject. Perhaps it's a beginning, And because we can talk about hours together on that, because I need not, because you are the experienced professionals, if this much of inputs are sufficient to you to think twice so far as the issues is concerned. So I take the opportunity and thank very much of my very good friend Vasudeva Murthy garu for providing me an opportunity to address the vital aspects of all these four things. I hope what of my little experience, I thought I may have justified the issue for the present. I look forward for your association and cooperation and for my advice on all the times. Thank you very much.
Members, are you having any queries or you want any clarifications? You can unmute yourself and you can ask, sir. Members, please, if you are having any doubts or you want any clarification, you can unmute yourself and you can ask him. Because he is available and he is very rich, he is having very good experience in that line of action. So, if anybody wants any clarification, Narendra garu, anything you want to ask? And Gicham. Members, please. I think Anirban garu, ఒక చాట్ బాక్స్ లేదన్నట్టుగా ఒకసారి చూడండి సార్.
Yes, we have sufficiently addressed.
Because before commencing this webinar, sir, Sarma garu,
Sir,
one of our members asked, when you are taking action through DRT, can we issue SARFAESI? When you are proceeding through DRT, can you take up this SARFAESI or can you choose IBC?
so far as SARFAESI proceedings and DRT proceedings can be proceeded simultaneously. When then SARFAESI proceedings are also there, the borrower approaches the NCLT that because to have the moratorium over the SARFAESI proceedings, generally the borrowers are approaching the NCLT also. Because SARFAESI proceedings and DRT proceedings can be proceeded simultaneously, and if there is any properties are sold under the SARFAESI, the amount recovered will be shown by way of a part satisfaction memo before the DRT, and the rest of the balance only we can pray for the OA certificate, recovery certificate, because the simultaneous proceedings are permitted. But mind you that the SARFAESI proceedings to initiate SARFAESI initially, if you are not having, suppose the limitation is there, if the limitation is there, you can file this OA first and then simultaneously you go for the SARFAESI proceedings. Because time barred, suppose 1 month my documents are going to be time barred. If I have not filed the OA, I mean if I have not filed the OA and proceeded against only the SARFAESI proceeding, I may be at risk.
Sir, members, are you having any doubts or you want any clarifications? Please unmute yourself and you can ask, sir. Sir, in one chart box, one question is there. What is the liability of the bank after auction if any problem in the documents about legality of the property?
Legal liabilities, first of all, law presumes that you have taken the properties, the securities are properly scrutinized and they are having a valid legal title report and valid verification. If there is any sufferance of there, if there is any sufferance of title is there, you cannot sell the property. Just like I cannot wash my hands and then say that not having property. Tomorrow, suppose my minor's interest is there. Without ignoring the minor's interest, I have taken the property under mortgage and that property I put to sale. Third party is purchaser, I am answerable to him. So this is the mortgage. When I'm selling the property, I must be 100% responsible and say that I am convinced with the title and then selling the passing of the title, because you are executing a sales certificate just because with regard to the extents or regard to the permissions or regard to the title. That's why that genealogy of the title can be studied up to 30 long years. What are the title deeds are there? What are the link documents are there? These are all the things that has to be taken. I can say because I sell the property to a third party purchaser, and can I say that I am not responsible for other things because maybe that I cannot respond. Maybe the courts are asking to return my money with interest, because the third party cannot be put under stake and then say, because of course he will have a physical verification of the document before beginning, and if any title inherited defective title is there, I cannot pass, because that rule of nobody can convey a better title than what he has. I'm a mortgagor. I must be satisfied with this.
Sir, Mohit Shagar, anything you want to ask? Sir, members, please. This is a very great opportunity before we are going to statutory branch audit. So it is better to clarify our doubts. So I think nobody is having, because your deliberations are very good, Sarmgaru. Thank you very much for your immediate acceptance when I requested you and you accepted it. Thank you very much, and we felt very happy, sir. Now I request our secretary, sir, Anirban Paul, propose vote of thanks for this session.
Thank you, dear Chairman. Good evening, members. This is the end of a very learning experience and a very informative session by Sri M.S.N.Sarma Garu. He shared a lot of information and experience that he has about the relevant acts. I'm sure when we go for the branch audits this year, we will not exclusively rely on the legal opinions when we are verifying the documents, and just satisfy that the compliance with these acts are done just because there is a legal opinion on it. I would like to really thank Sri M.S.N.Sarma Garu for his detailed presentation, for having shared the nuances of the specific acts of SARFAESI and insolvency and bankruptcy, for having shared the areas of hurdles and the areas where we need to take precautions both as auditors and also to inform the bankers as to where they have to be more cautious. We thank you very much, sir, for your very detailed explanation and presentation. We would like to have you on a physical meeting in future, if possible, to learn more on these acts. I thank you all. I thank on behalf of the managing committee, it's our sincere thanks for your presentation, sir. I thank all the members for having attended this seminar. We would like to present a small memento on behalf of the branch and managing committee. Please accept our memento, sir. And just to inform the members on the upcoming programs, we have scheduled 2 more programs on bank audits. On 17th March, we are planning a full day seminar, which will be on IRAC norms and audit under computer environment by CA Niranjan Joshi and CA D Premnath. On 23rd March, we have scheduled another seminar on which has been, as per the instruction of the CA Institute, it is under R. Vaidinath Memorial Lecture, and the lecture will be on the practical approach of bank audit by CA Veeramani Garu, a very experienced and learned speaker. I wish you all a very good day, and I hope you will be present for the future programs also. Thank you very much, sir. Thank you.
Sir, afternoon also that we added, sir. So workshop, sir.
Okay.
23rd afternoon.
On 23rd afternoon.
That by our Raman Kishore, sir.
Wow. Thank you, sir.
Thank you. Just now that is confirmed, sir. Because at the time he was in the class, so just now he
Acha, confirm. That's very good.
confirmation whether he is available to or not, because he is taking the class. So Nellore and other chapters he has already given consent. So
that's good, sir. Yeah, it will be a detailed learning opportunity for all of us. Thank you,
yes.
sir.
Thank you.
Thank you very much, sir. And good day to you all. Thank you.